What's up, everybody? We finally have some answers in the Bryan Kohberger case. When is the trial? How long do they expect the trial to be? And will this trial date stick? Can't wait to read your comments. Hit the like button if you haven't already and hit that subscribe button. We are this close to 400,000 subscribers. All right, we have the hearing queued up and ready to go. I have not watched the whole thing yet, so this will be the first time I'm watching it. Instant reactions with you. Let's get to it.
CR 2922-2805. Present in the courtroom is Mr. Kohberger, represented by Ms. Taylor, and Ms. Massad and Mr. Logston are participating over Zoom remotely. The state is represented by Mr. Thompson and Ms. Jennings, Latah County Prosecutor's Office, and Mr. Nye and Ms. Beatty are participating over Zoom remotely. So we're here for a scheduling order.
What are we here for?
And I think we're about
The purpose of a scheduling order, just for anybody that's new or doesn't know what's going on or why we're having this hearing, is at some point, one side or the other wants to push this case towards trial. And if they can't get an agreed upon trial date with the other person, they push it to the judge and say, Judge, we need it. Judge says we need it. We got to put all our calendars together, force a trial calendar to be set up so we know when the trial date is, but not just the trial date. Because you start from the trial date and you work backwards on when experts are due, when discovery is due, when expert discovery is due, when the witness list is due, when the exhibit list is due, when responses are due, when dispositive motions for summary judgment, for dismissal, whatever it may be, motions to suppress, whatever you're going to do in the case, we have to have deadlines for everything so we know what to expect, because there's no such thing as an ambush or a trial by surprise or hide the ball in the litigation system. At least it's not supposed to be like that in America.
13 months from the arraignment, and I think
it's already been 13 months since the arraignment, which is basically twice as long as a speedy trial. Bryan Kohberger waived that at this point, but it's been a while, so we need to get something set.
At this point, this is my opinion, that we're getting to a point of diminishing returns, and
that's interesting too, because we don't know what the judge has seen. The judge has seen and heard a lot more than we have in these sealed hearings and sealed documents. When he says that we're getting to the law of diminishing returns, it means you guys seem like you're just spinning your wheels. It seems like you have all the important discovery. It seems like you should know who your experts are. You should know who most of your witnesses are. We have the alibi. We have the jury stuff going on to see if we need to change venue. So what are these delays actually accomplishing at this point? Because we only want to delay if we need to. If stuff has to happen, if evidence has to be gathered, if motions have to be filed. If you need time, I'll give it to you. But at this point, diminishing returns makes it seem like he doesn't think either side really needs a lot more time.
sent to council last Friday on a proposed scheduling order for a lot of things.
So each side, before they even got to this hearing, already saw the dates. That's not uncommon. We usually go through them, so we know what our objections are going to be, what we agree with, what we disagree with, what we want to change before we come to the hearing, so we're not just having to do it off the top of our head. Lawyers, judges, nobody likes doing everything off the top of your head. We like researching, we like drafting stuff, and then we like arguing about it orally.
Deadlines, including setting the trial. And so I also have set this hearing so that we can discuss this and see kind of where everybody is. So let me start with the state. Thanks.
Thank you, Your Honor. We've reviewed the court's proposed scheduling order with the attorney team, and we are agreeable to it. It makes sense that we do the trial in the summertime when high school is out across the street and when the university is out and the conflicting activities. And the schedule that Your Honor proposes is acceptable to the state. I would note just minor details.
Before he has an issue, he agrees, which is not surprising. And number two, from the very beginning when we started talking about this trial, when they made the arguments about why summer made sense, I thought the judge would go for that. I thought it made sense as well. Sounds like that's when the judge has picked. We haven't officially heard it yet as part of this meeting, but it's going to be summer of 2025. And obviously the state is down for that because that's what the state originally asked for, except they wanted it to be this summer, which is crazy to think about because they haven't even provided everything. But nonetheless, summer makes the most sense.
The detail that June 19th is also a legal holiday. The court specified July 4th as a legal holiday. We wouldn't be able to hold trial, but
Sure.
19th as well. Other than that, we have no objection to the court's proposal.
All right.
So the trial is going to be over June 19th and July 4th, 2 federal holidays. They won't be able to hold court on those days. We knew about that Karen Reed trial happening right now. They took off June 19th, among other days. It hasn't gotten to July 4th yet, but if it does, you better believe the jury's not going to be deliberating on July 4th. So he's saying we're going to have to miss a couple days during this trial as well.
Right. Thank you. I mean, as I went through all of this, I mean, there's going to be a lot of motions, a lot of hearings, a lot of work. There already has been a significant amount of work, as we all know. And when I tried to balance this out, I do think it's pretty fair, balanced, and I hope realistic. So, Ms. Taylor.
Thank you, Judge. Your Honor, first, I know the court has listed this as taking place in Latah County. We haven't been heard on our change of venue yet. That's to come.
Totally understand that.
So
he put in there that the trial is going to happen in Latah County. She's like, well, we're not agreeing to that. And that's important for her to put that on the record because later that could be used against her. It's like, at the scheduling order, you never had an objection to Latah County. It clearly said in the scheduling order that the trial is going to happen in Latah County. It may seem very obvious to all of us, and this judge doesn't seem like he's a stickler and he would go for that. But if the state argued it, technically on the record, she had the opportunity to object to the location of the trial, and she didn't. So very smart of her to put on the record that, Judge, even if we agree to this date or some of these deadlines, we are not agreeing to Latah County.
So I don't want anybody thinking I'm agreeing to Latah County is all. The June of 2025, that's the time frame that we have been working towards. I am hopeful that we can come in there. We're working towards that date. I think it's
also very smart of her to always keep it open. We're trying. We've been trying to work towards that date. We've continued to try to work towards that date. It's been our target date. We heard about this last year, right? When the state wanted to push it to this year, they said we should be able to do it by next year. The judge was thinking about doing March. And I always said, if he did March, that would just set up a continuance to June. If he did June, there's a much better chance of that trial date sticking. We're going to listen to all this, listen to the deadlines, see if I still feel that way at the end of the video. But I never thought March was going to happen. The defense has given us indications they didn't think March was ever going to happen. And June may be possible if everything goes according to plan. And that still seems like what they're saying.
It's reasonable to set that date. As the court's aware, mitigation is something that takes a significant amount of time. We've had that underway since the day we took this case.
Mitigation is if he gets convicted and they go to the penalty phase where it's either death or a life sentence, mitigation factors as to why he should get life and not death. It's very important, very time consuming, unless you just waive it like Chad Daybell. The Nicholas Cruz trial, that was the entire trial. They're saying it takes a lot of time, a lot of effort, and we've been working on it, but that's something that makes this harder than your average case. So June is about 2 years from arraignment, which may seem like a long time. It's really not. That's probably average for a case to get to trial in 2 years. They're saying an average timeline for an above average case as far as how hard it is and how voluminous the discovery is. We're going to do our best, but we just want you to remind you we have some difficult issues here.
We continue to work that very hard. I spoke with our mitigation expert last night about this date. And there's a lot of work yet to be done, but we're still working towards that. So I think it's reasonable to set that. I just want the court to know that that's not finished at this point. That's very much ongoing and new things are coming out that we need to follow up. But with that said, I think it's reasonable to go ahead and pick the June of 2025 as a trial date at this time.
And by the way, I think you understand that, all counsel understand that, but this is a 3-month trial. So
something else we learned, confirm this is a 3-month trial. Now, I don't even know yet if that includes the penalty phase, but 3 months would mean June, July, August. So that's the entire summer, basically, of 2025. buckle up, folks, because we're going to be following it, obviously. But any delays, and then it screws up the summer timeline. So I think the judge is going to start to be a stickler on the calendar. I hope he is, because there's no reason that if we're setting this trial date now, we should be able to get it done in June. Now, where I still want to hear what the defense has to say, because she's going to leave some caveats open, I'm sure, and we'll see if there are any more major delays or screw-ups by either side over the next 12 months, which only God knows. But a 3-month trial period, if you think about that, it's basically what Karen Reed was, if you include jury selection and now jury deliberation. And I feel like this case is more complex than that, and especially with the penalty phase. And I think it's going to be much harder to pick a jury in this case, because this case has had much more national attention. I know Reed does now, and it had a lot before. And maybe it's just me. Maybe it's just in the world I live in. This case has seemed to have more eyes on it from the jump than Reed. But you guys correct me if I'm wrong, because you guys may have your finger on the pulse better than I do.
I was calculating 2 weeks to set the jury.
I think that's fair. I think 2 weeks is fair. It's a long time, but they're going to need a long time in this case. I think the longest I've done is 2 days, to pick a jury. Oh, no, that's not true. Well, it was a case I assisted on. I was not a lawyer yet, working in my dad's office, that he picked a jury. That took longer than that. But I'm not sure.
Then 8 weeks of trial, and then 2 weeks for mitigation and sentencing. And I mean, that's
So 2 weeks to pick a jury at the beginning, 2 weeks for mitigation and sentencing at the end. So that's 4 weeks. So that means the trial is going to be 8 weeks in the middle. Very similar to Karen Reed's timeline, a little bit longer, but very similar to what we've just kind of watched unfold in front of us in a trial.
a guess, but I think it's enough time for all of those things to take care of. And obviously, the last 2 weeks would only be if Mr. Booker was convicted.
So if it's an acquittal, then it's only 10 weeks instead of 12.
Okay, go ahead.
Thank you, Your Honor. I do want to bring up a couple of issues I have with some of the deadlines. I looked this over. Our team has talked about it. I've gone over this with Mr. Koberger. I do have a couple of concerns about the deadlines, and I'll just bring those up to
So
the
let's hear what her concerns are about the deadlines.
court for the court's consideration. As far as motions challenging the death penalty, and that's in right under motion practice letter A that the court has on its draft, we can have a lot of those filed by September 5th. I would note for the court that that's ahead of the state's final discovery date, and that's ahead of the state's deadline to produce its aggravation case that it will use.
She's basically saying, I don't want to have to file my motions under this section before the state provides everything, because that could change it. So if something additional comes, I'm going to have to supplement it. Obviously, she's protecting the record, but obviously the judge is going to allow her to do that. So obvious.
We can meet this September 5th deadline, but we're going to ask the court to give us a little leeway when there's something new that comes our way. If there's an amendment to a motion or a new motion that becomes relevant based on something new, we'd like a 2-week window after receiving something new to file that.
Totally fair.
But the bulk of it we can get in by the deadline that the court has asked here, and that's just not a problem.
Sure, I understand that. I mean, I looked at that. I wanted to have that early because, it's a bigger question.
Yeah.
And I was aware of the Ross case. I think you had 16 motions in that case. So, I wanted to sort of address those issues early.
Your Honor, we can definitely do that. We can address a lot of things early. We just don't want to be precluded from bringing an amended motion or a new motion if something new is filed that would have been relevant to something we've already filed.
He almost couldn't do that to protect the defendant's rights, but also it would create a continuance situation. So he's obviously going to do that, but she's doing her job protecting the record.
I'm not going to prevent you from doing that.
Perfect. Thank you.
And by the way, a lot of these deadlines, I mean, you can certainly do them earlier if you'd like to. I would encourage everybody to do that.
Lawyers don't do
Thank
that.
you.
Your Honor, then moving on, the motions in limine under letter C, the court has suggested February 13th as the date for that. I think in
Motions in limine is what stuff you don't want to be allowed in before the trial even starts. You say, Judge, this is inadmissible for X, Y, or Z. The judge says, okay, it's inadmissible. It's not going to come into trial. Or no, I disagree with you. It is going to come into trial. You need to know that for your strategy. We're going to talk about in opening statements. We're going to talk about closing arguments, which you're going to ask witnesses about. So it's important to do that. I got to be honest. Sometimes our motions in limine get heard the day before trial or even on the first day of trial. So to have it 4 months before trial seems aggressive. And I'm sure more stuff will come out. And the other thing with motions in limine, sometimes you don't file a motion in limine, something pops up at trial, you can still object and ask the judge to exclude it. So it's not like you lose that argument if something comes up that is inadmissible. Because then again, the interest of justice, even after the deadlines, the judge is not going to let inadmissible testimony come in a criminal case like this.
in large part, we can do some by then, but the exhibits that we'll exchange and witness lists that we'll exchange aren't due until after that. And again, I think there might be additional motions that would be relevant after those things have been exchanged. So if the court wanted to move the whole deadline, so we had all of those motions in limine at once, I think that would be reasonable. But if the court wants to keep this deadline, as long as we have the ability to bring more motions in limine based on new filings, we'll be okay with that as well.
Sure. And I was also thinking about, I guess experts, for example, I mean, they may have longer hearings that, we're going to have to work through all of these things. I mean, this is just a structure.
This is more of a guide than it is a mandate, but he wants to push people. He wants the deadlines to be sooner, assuming there's going to be delays, there's going to be continuances, they're going to push it out a week. He's assuming all that's going to happen. So he just wants to get it set so everybody's on the same page. So we're going to push this as quick as we can.
Thank you. The court had listed March 14th as a trial brief date, and that is ahead of some of the other deadlines, recognizing that the
Trial brief is basically a summary of the whole trial, what you expect, your witnesses, exhibits, things like that, experts. So everybody can be on the same page again. So there's no surprises. Not every court requires a trial brief.
trial is the innocence phase, and the sentencing phase, if it happens, is the mitigation and aggravation. I would just say this is a fine deadline, but we won't be touching anything to do with our mitigation by then, if that's what the court anticipated.
Yes.
Okay, perfect.
And by the way, that trial brief date is when the judge originally wanted to have the trial. So she's saying if we do a trial brief, it's only going to be on the innocence. So it's like the phase of did he do it? We're not going to put any of the mitigating factors for the sentencing phase in there. It's just not going to be ready yet. That takes time.
I think we had March 3rd for mitigation. I figured by then you would pretty much have that in hand.
We hope to. That brings me to the last.
Not making any promises, Judge, but we should. He said, listen, by March, you should still have it in hand. It's only 3 months away from the trial. And she may, but it may not all be summarized as cleanly and packaged as neatly as the innocence part.
Last point I wanted to talk about. The court has proposed setting a mutual exchange of aggravation and mitigation materials. And I'd ask the court to reconsider that. We will.
Mutual means at the same time, right? She's saying, I don't mind turning my stuff over, but turning it over at the same time, it seems like she has an objection to that. Let's hear why.
Aim for our March 3rd deadline. That's our plan right now. If something changes that, then we'll come back and let the court know and talk to counsel. But would ask that the state's aggravation package be provided to us earlier than the same day as our mitigation. Should we get to that point, the state has the burden of establishing the statutory aggravators. There are some things I think I might be able to guess about how the state's going to try to present information, but I don't think I should have to guess. I think I should have that information well ahead of providing the mitigation that will be presented in response to any aggravating information that's presented by the state. So I'd ask the court.
Again, we don't want surprises. She should know what the state's going to argue so she can respond to it. This isn't a huge ask. I think the judge will say yes to this, and she's right as far as the deadlines go. Mutual is fine. Or, I mean, she doesn't want it to be mutual. Mutual is fine as long as you can supplement and respond to each other with what you have and what you find.
Court to set the date for the state to produce its information much earlier than ours. The state filed its notice a year ago yesterday, and
So she's saying the state should already knows, which is pretty much true. The state's is easy. How heinous this crime is, multiple deaths, the horrific nature of it. The states should be easy with the aggravating factors, right? We already know what they are. And that's why she's saying I can guess, but I shouldn't have to guess. So just make them file theirs earlier so I can respond and we can keep this truck rolling.
I have a lot of questions about what the state would intend to use to try to establish many of the statutory aggravators they've listed. I know I've heard the court talk about super due process in a capital case, and I think it's appropriate for us to be on notice and be provided discovery, to be provided a full range of what the state intends to use to establish those if we ever get to that point. And I think we need those ahead of our deadline for mitigation. So I'd ask the court to move that deadline up quite a bit earlier. And that's it.
Thank you very much. Mr. Thompson.
So she's okay with her deadline in March, but she wants the states to be earlier. So if theirs is February, then it gives her more time to respond by March. Because if the states is March, again, she's not saying it, but it's a little bit like, Judge, if you really do this, there's probably going to cause delays. We don't want delays, so I think the judge will be inclined to move it up eventually, or at least give her time to respond or supplement.
Do you have any issues about having the aggravation in advance for a period of time?
No, sir. As long as we will have the option, the ability to supplement that once we see whatever the defense plans to offer in the way of mitigation.
So it's so reasonable. The state doesn't even object to it. They're like, that's fine, Judge. As long as we have an opportunity to supplement if they do something crazy or we didn't know about, or we need to respond to their response and supplement whatever it is that we filed, we're okay with an earlier date. She's right. We do know what we're going to argue already. We knew a year ago when we filed the notice. We're prepared. We're ready, Judge. So I like that response from Thompson.
Well, I'm appreciating that, with these deadlines, that we're going to have supplement all the way along. I just don't want to be scrambling around a month before the trial. We're all going to be very, very busy. And the more we can resolve certain motions, supplements, whatever we need to do, I'm trying to do this sooner than later.
Yes, sir. And that's our preference as well.
And Ms. Taylor as well.
Yes, Your Honor.
But just to make sure, though, I mean, you have to do your job. And
Ms. Taylor's like, yes, Your Honor, as long as I can represent my client appropriately.
the state has to do its job, and I have to do my job. But I think this is a great step, okay, to set
I agree. Well done by the judge.
these deadlines and hearings so that we can move through this. It's going to take a while, but anything else we need to address today, Mr. Thompson?
I mean, it's almost 12 months, right? So they've got plenty of time to work, but there's still a lot of work to be done. He said a lot of work has already been done in the last 13 months. So I like when judges set it out and really hold people to it 12 months in advance. If it's 3 months, it's impossible. It's so hard for lawyers to get a bunch done in 3 months. 12 months, we should be able to get most everything done we need to, even in a difficult case.
Thompson,
I don't believe so. Thank you.
Ms. Taylor.
No, Your Honor. Thank you.
Okay, well, it's very,
Especially because all of these lawyers are focusing primarily on what? This one case.
very short, and I'm grateful that everybody's working together. Thank you. Okay. Take care, everybody. We are adjourned.
There's
All
time
right.
left. I don't know if anything else happens, but. So no, seems like that's it. All right. So, hey, based on the arguments, I would put this at a 60-40 chance this trial date sticks, which is actually pretty good for a first set trial date. I guess it's not technically first set because they had one set within the speedy trial period, but I think there's a better chance than not that this case goes to trial in June of 2025. And I hope it does because the summer months make it easier and better on the venue. Again, if the venue changes or anything big happens, that could all create issues. So that's why I'm leaving a 40% chance that it doesn't go. But I'm hopeful based on the arguments both sides. Everybody seems pretty confident, even the caveats that Ms. Taylor puts in there, which I appreciate and are appropriate for the record and for her to represent her client effectively. Thompson and the state seems like they're ready. They're not afraid of the deadlines. They're ready to roll. So that's all good. That's all encouraging as far as getting this case to trial and getting justice in this case, right? That's what the trial brings when we can't have an admission and some kind of plea deal where everybody agrees what happened and give the victim some closure and get an appropriate sense that everybody agrees on. Not going to happen. Trial is where we get the justice, where we get the even playing field, where we get the public notice and the public to keep people honest, right? That's what's really important about this. So let me know what you think and let me know what questions you still have in the comments. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.